Subscribe to our YouTube channel and press the bell icon to get the latest updates.
A 5-judge constitution bench of the Supreme Court is set to hear petitions challenging the 10% quota for the economically weaker sections, that is the EWS quota. Now, the case involves a challenge to a constitutional amendment and includes interpretation of several provisions of the Constitution as well. So, we began KYC or Know Your Constitution this week by telling you more about this. The quota was introduced by the 103rd Constitutional Amendment in 2019, and it provides for a 10% reservation in government jobs and educational institutions for the EWS category. And to do this, it had amended Articles 15 and 16 of the Constitution. Now, Article 15 of the Constitution bars discrimination on the grounds of religion, race, caste, sex, or place of birth. And Article 16 guarantees equal opportunities in matters of public employment. So the 2019 amendment essentially added a clause to both these articles, allowing the Parliament to make special laws for the EWS category, similar to what it does for SCs, STs and OBCs. Now it is upon the state governments to notify who comes under the EWS category to be eligible for reservation. And what are the grounds on which this reservation has been challenged? Firstly, the Supreme Court will examine if the quota violates the basic structure of the Constitution. Now, we've told you about the basic structure doctrine before. There is no set list of what constitutes the basic structure. For example, over the years, federalism, secularism, equality, rule of law, all of these have been held to be a part of the basic structure of the Constitution. Now, in this specific case, the court will be looking into whether special provisions like reservations for socially disadvantaged groups is also a part of the basic structure. And if it rules that this is the case, then the bench will examine if the amendment violates this by promising a quota solely on the basis of economic status instead. The court will also be looking into whether the constitutional amendment violates the Supreme Court's landmark 1992 judgment in Indira Sawhney versus Union of India, which is also known as the Mandal Commission judgment. The Supreme Court had then in 1992 capped reservations at 50% and had also said that economic backwardness cannot be the sole criteria for recognizing a section of people as a backward class. Thirdly, private unaided educational institutions have also argued that by compelling them to implement this reservation policy, essentially they'll have to admit students on any criteria other than merit. They're saying that their fundamental right to practice any trade or profession under Article 19(1)(g) is being violated. The case around the death of actor Sushant Singh Rajput has seen several arguments between the Mumbai police and the Patna police in the Supreme Court. Now, with the Bihar government recommending a CBI investigation in the case, the Central Bureau of Investigation has also been roped into the jurisdictional issues raised so far. But does the CBI need a state government's consent to investigate a crime in a state? The answer lies in a pre-independence law and the Constitution, and that's what we told you about next on KYC. Now, the CBI was formed under the Delhi Special Police Establishment Act 1946. The agency was set up in 1963 through a resolution by the Home Ministry. So, its primary jurisdiction is confined to Delhi and the Union Territories. Now, Section 5 of this Act says that the central government can allow the CBI to investigate specific offences in any state, but Section 6 adds that this cannot be done without the consent of the state government. And this is essentially because of the fact that public order and police are a part of the state list in the 7th schedule of the Constitution. As per Article 246 of the Constitution, the state government has exclusive powers to make laws on the subjects mentioned in the state list. Since entries 1 and 2 of the state list mention a public order and police, the CBI is required to take the state government's permission for investigating an offence in that state. This might be a general consent to investigate certain specific offences or a specific consent relating to a particular case. But the CBI doesn't need the state government's consent if the High Court or the Supreme Court uses its powers to direct a CBI investigation in any case. As for Sushant Singh Rajput's case, the Bihar government has already given its consent to the CBI, and accepting the state government's recommendation, the CBI has agreed to take over the investigation. But the Maharashtra government has now argued in the Supreme Court that the CBI will need its consent to look into the case. Now the matter is up to the Supreme Court to decide. On 15th August, Prime Minister Narendra Modi will become the longest serving non-Congress leader to occupy the office of Prime Minister. But what does the Constitution say about the post of the Prime Minister and his tenure? Now, Article 75 of the Constitution says that the President needs to appoint the Prime Minister, and the President then appoints the other ministers on the advice of the Prime Minister. Now, as per convention, the President appoints the leader of the party or the alliance which is in majority in the Lok Sabha as the Prime Minister of India. A member of either of the two houses, that is the Lok Sabha or the Rajya Sabha, can be appointed as the Prime Minister. But the Constitution does not specify any particular term limit for the post. Technically, the full term of the Prime Minister would be for a period of 5 years, coinciding with the normal life of the Lok Sabha. But this term can end sooner if the Prime Minister loses the vote of confidence in the lower house. This is because Article 75 Clause 3 says that the Council of Ministers, headed by the Prime Minister, shall be collectively responsible to the Lok Sabha. The Lok Sabha rules then embody this rule by laying down a mechanism allowing a no confidence motion to be introduced in the House. They allow any Lok Sabha MP who can garner the support of 50 colleagues to introduce a motion of no confidence against the Council of Ministers. Then a discussion on the motion takes place and the motion is put to vote. The Prime Minister generally resigns if he loses the motion. Before Modi, it was Atal Bihari Vajpayee who held the record for the longest serving non-Congress Prime Minister in India. He served in the office for a total of 2,273 days across 3 separate terms. Jawaharlal Nehru holds the record for the longest serving Prime Minister in the country. Nehru spent over 16 years in office from 1947 to 1964. His daughter Indira Gandhi holds the second longest term and is followed by Manmohan Singh. This is Apoorva Mandhani for ThePrint. For more such videos, subscribe to our YouTube channel and follow us on Twitter, Instagram and Facebook.